New changes in UK immigration rules which are being recorded under a complete new name, part suitability. In today's video, we will discuss one portion of that relates to the criminal record of the applicant and that guides the home office officer, immigration officer, that how they should assess and on what basis the application comes under a mandatory refusal. The first point is custodial sentence of 12 months or more. If an applicant has been convicted of a criminal offence in the UK or overseas and received a prison sentence of 12 months or longer, the Home Office is required to refuse the application. For example, if someone who received a 15-month sentence for fraud, even several years ago, a long time before, would automatically fall under this rule and the applicant will face a refusal. Number 2. Persistent offenders or regular offenders. This applies to individuals who repeatedly break the law of land. Even if the offences are minor, a pattern of ongoing offending can show a particular disregard to the law which will lead to the refusal of the application. For example, if a person is convicted multiple times for a shoplifting or a repeated driving offences over several years, could be considered a persistent offender or a regular offender, resulting in a mandatory refusal. Third, offences causing serious harm. No matter if it was a small offence, but if it has caused a serious harm. A refusal is also required when someone has committed an offence of this level that has caused serious physical, psychological, or financial or social harm to someone. An applicant who received a short sentence for an assault that caused long-term injury to the victim could be refused because of the seriousness of the harm caused. So this new guidance covering the criminal record of the applicant must be considered very carefully when you are in the UK on a limited leave to remain. This may harm your route, your life in the UK,